Welcome, everybody, to Litigation Updates 2022. This is Renato Mariotti, and it is my distinct honor to be doing this webinar with you alongside the Honorable Douglas Lang. Justice Lang was a judge on the 5th District Court of Appeals in Dallas for many years, and he is off the bench and has now joined our firm in Dallas. And I cannot tell you how excited I am to be doing this alongside him, because he really has a wealth of experience. Just in working with him on this webinar, I've learned a lot myself from the insights he has, and just to give you a taste of what you are going to hear from him. He has so many friends on the bench from his time there, and he is going to be sharing with you some of the secrets he's learned from them, some of what they're telling him about what they see. So buckle in. We have a really exciting presentation today with a lot of insights, not only from him, but from me as well. You can see our photos there on the left. There I am pre-pandemic. Without my COVID beard. I was a federal prosecutor in Chicago for almost a decade, and so my practice now involves a lot of high-stakes litigation as well as internal investigations and white-collar criminal defense, and I also handle SEC, FTC, and other enforcement matters. Before we jump into this, I do want to make sure that I handle a few housekeeping matters. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer those questions during the webcast, but if a fuller answer is needed or we run out of time, we are collecting your questions and we will answer them later via email. So please don't be shy about submitting your questions. Justice Lang and I are happy to answer them, and we're going to try to work as many of them into our presentation as possible. A copy of the slide deck is available in the resource widget. We encourage you to download download that slide deck if you think it's useful to you. You're going to find answers to some common technical issues located in the help widget at the bottom of your screen. And most importantly, listen up. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general credit. In Missouri, it's approved for 1.2 hours of general credit. And in New York, in either transitional or non-transitional, it is eligible for 1 hour in areas of professional practice. We award CLE based on attendance for the entire 60 minutes. And due to changes in jurisdictional requirements, you're going to notice that we don't do automated pop-up attendance checks anymore. So what some of these jurisdictions require is that we display secret words in 2 multiple choice polls during the webinar. You're going to be required to select today's secret word from a multiple choice list. And so please respond to those 2 polls to demonstrate your continued engagement and to earn the full CLE credit. And the good news is that we are going to highlight those secret words for you. I'm going to very loudly broadcast them to you. So that is not, so it should be easy for you to follow along. All right, so let's get right into it now. As a starting point, I really wanted to talk about the impact of the pandemic on courts. Now, Justice Lang has got all sorts of insights that he has from his time on the bench and from his conversations with some of his former colleagues. But what I wanted to do is introduce some statistics to ground this. And when I was working on this, there was just a wealth of information that demonstrated some trends. And what I decided to do to distill that down is to focus on one court near me, and that's Cook County Court. So this is the state courts for the entire city of Chicago and other areas. So one of the largest court systems in the country, I think the 2nd largest in the country. And it gives you a sense of what we see. If you look at that graph to the right, you can see the average rate, which is in pink. And that rate, you can see it pretty constant, and then it literally falls off a cliff starting in about March, April of 2020, which is when the pandemic went into high swing. And you can see that cases are continuing to be initiated, but the cases were not getting resolved. In fact, if you look at May, they're down to literally 0.1. And I will just say that as somebody who, I practice mostly in federal court. I say my practice is primarily in federal court, not just in Chicago, but across the country. But I do have some cases in state court, particularly in Chicago. And the Chicago federal court, the Chicago state court, the Cook County court, is like many courts across this country where they were not set up for video conference. They were not set up to be handling cases remotely. And so the reason that it falls off a cliff in May and June is that they literally had no video conference capability. I think the entire court had a Zoom license that allowed for one Zoom at a time. And this is in a court system with well over 100 judges. So, not realistic to conduct all of that business over video conference at that point. So things just came to a standstill. Now, things are on the rise now. You can see that, they're getting closer to normal throughout 2021. And now things are spiking in late 2021. And the reason that is the case, with vaccinations, judges are eager to resolve cases, and there's a major backlog. In other words, now it's not enough to get back to that average rate, that pink line. Now, in order to catch up, judges are going to have to go much further and try to aggressively resolve cases in order to get their dockets under control. I have a friend who's a federal judge who told me that she gets a new case every single day. And so she doesn't resolve at least one case a day. Her docket gets out of control. And, in the pandemic, if you're not resolving cases for months on end, you can just develop a backlog that there needs to be some catch up. So if we look at this, like I said, that's basically the point here. That backlog needs to be caught up on, and I think it definitely has some winners or losers. We're going to talk a little bit after we discuss the impact of the pandemic. We are going to talk a little bit about how this impacts your case, how you can, the strategies that you can employ as a result of this. But the bottom line is, now judges are working hard to dig themselves out of that hole and get things back to pre-pandemic levels. And there are some wrenches in the works there as well. So if you look here, one thing that has not completely rebounded are trials. And there's a reason why. In most court systems, there are limits on the number. First of all, they're having trouble getting jurors. And there are limits on the number of jury trials they can conduct because, at least in many jurisdictions, and Cook County is one of them, they are using rooms that give the jurors more room so they don't have to be all over each other. Like many courthouses, the state court in Chicago has small courtrooms. Jurors would basically be on top of each other in a very small room deliberating. And that is viewed by the court as inappropriate. And so now you literally have multiple courts, multiple rooms in a row that need to be freed up in order to conduct a trial. So if you see, look at the left of this bar graph, you're going to see trials, 60 or above per month, and they have not reached that in any month since the pandemic. And what that means, of course, is that the backlog, while this helps with the backlog, it does not resolve the backlog. And in fact, jury trials are a smaller percentage of overall trials, which means that cases that require a jury trial are more backlogged than others. One thing that has had an impact in Cook County, and I think has repercussions elsewhere as well, is that in the Illinois Supreme Court, announced reinstatement of speedy trial rights in state cases, which had a significant impact because it meant that criminal cases had a clock and had to get resolved one way or another. I have noticed this elsewhere. I do a lot of federal criminal work throughout the country, and that it has led to some of my clients getting amazing offers or deals from the government. I've seen other cases where the government is very agreeable to very long extensions of time in cases, whereas usually the government is working hard to push the cases forward. There are other cases that I think have not been brought in part because the government does not want to put themselves on a clock. But it has an impact in civil cases as well. I do more civil work than I do criminal work. And in my civil cases, what I've noticed is that judges just don't have trial dates because the trial dates they have need to be devoted to criminal cases because those defendants have constitutional and statutory rights to speedy trial. So judges have to prioritize those cases, which really puts a pressure on civil cases to settle before trial and obviously produces winners and losers in doing so. All right, now I'm going to hand this off to Justice Lang.
Oh, thank you, Renato. And by the way, the check's in the mail for all the nice things you said about me. Comparing to what happened during COVID to now, just kind of like in Cook County, things are materially different. However, I need to tell you that the federal courts that I know about and I'm in the Southwest and in the South pretty much had their own schedule, their own determinations as to whether they were going to have live trials or jury trials. I'll give you an example. Justice Amos Mazant he was a justice. He's now on the federal bench. Judge Mazant is a federal judge in Sherman, Texas, which is 65 miles north of here. He didn't shut down at all. Only one time, actually, and that's when everybody in the courtroom and in the courthouse got COVID. It was scary, but once that cleared up, he's back. So it has been pretty much a decision by each district and each division of each federal district as to whether they were going to have live trials. Some did have Zoom trials. I've heard about some very significant problems on Zoom trials. Maybe you've heard it, but I'm getting this from the horse's mouth, so to speak. There were some jurors who weren't paying attention, obviously, and they had to actually pull them up short, and others were actually receiving phone calls and walking off screen. There was a real problem with some documentary evidence being presented to everybody on the visual courtroom, and many times lawyers had to have their own special technical expert with them, which adds another layer of expense and problems. Federal circuit courts for appellate courts, they pretty much did whatever they wanted also. I can say that I appeared in the Fifth Circuit for a live oral argument last July. I walked into the courthouse. There was no real mandate that I wore a mask. It was rather surprising. People in the courtroom, it was just whatever they wanted to do. The panel of three judges they were not wearing a mask. It was pretty much wide open. And my friends on that bench told me that they had never shut down. The state appellate courts, they were all pretty much shut down during COVID. The Supreme Court of Texas just told everybody you're not going to have anything live. So I've done several oral arguments by Zoom. What's going on now, I'm told by my friends on the trial bench, in particular the state trial bench in Dallas, is that they are really moving very fast. As Renato was showing you with the Cook County, they're trying to get everything moving. And what they decided to do first, which is the practice before COVID, but they're really pushing this, is where they can determine that a jury trial can be tried fully in one day. They are calling those first. And those that are more going to take more extended period, they're trying to sandwich them in. Motions, hearings on motions were, of course, handled by Zoom, and I was present for quite a few. But I'm told that the trial judges, at least the Texas trial judges, in most cases in the larger cities, are going to stay on Zoom for those hearings. As one judge told me, he said, you know, if in the old way, when you were appearing in person for a 10-minute hearing, it might take you an hour of traveling to the courthouse, parking your car, and sitting around and waiting, and then have 10 minutes, and then, you know, have to reverse the process. That was expensive for clients, and it was also troublesome because it just slowed things down. But this judge tells me that that's probably the new normal. Unless it's really a complex hearing, they're just going to do it by Zoom. I questioned from oral arguments that I was involved in that were done by Zoom and hearings where I was involved by Zoom, how effective one can be, because the problem is that you don't really have that ability to feel what's going on. You don't have that interaction by standing in close proximity to the people on the other side or to the court and to see really what's going on. Those nonverbal signals that you get, I think, are very important. But I think it's the wave of the future, as I said. I am seeing on websites around the country for federal and state courts that it's now pretty much you need to check what's going on locally. That has to be, you know, a local option. I will say that in the rural areas and this state, like Illinois and many others, when you get outside of the big metropolitan areas, there are lots of courts that are used to doing things in person. They were reluctant to shut down, and I think everything's going to be live. But the word to the wise is always check. Call the court coordinator, call the clerk of the courts, and find out what's going on, because you never know what's going to happen. And some judges have told me that lawyers have to relearn how to present live in some cases, because they were just used to being able to do things very casually and informally. That's no longer allowed in most of the courts where I know the judges. That's about where we are, Renato.
Well, thank you, Justice Lang. I will say that I have seen, as somebody who is practicing across the country, a lot of diversity in courts and their practice as well. In other words, you know, here in Chicago federal courts, we usually did everything live. We had no statuses that were handled by, let's say, filing a report, as is usually done in the Southern District of New York. And now we've switched to phone as opposed to video. So now I've been handling court appearances via telephone, sort of like how we're handling this. And in fact, I've even argued very important motions, summary judgment motions, TROs, other things via phone even recently, even as the pandemic has gotten better. In other courts, what I've seen is fewer court appearances being conducted. In LA, for example, where I have a federal case, fewer appearances at all, very very limited, hearings even by telephone or Zoom, and the hearings that we have had are via Zoom. So, but in other jurisdictions, as you mentioned, Justice Lang, they are really not much has changed, and judges are trying to do everything live. So you really have to understand your jurisdiction, as Justice Lang just mentioned. And I want to talk a little bit about how you should manage this change. In other words, Justice Lang and I have talked about, pretty significant change in practices. The statistics I laid out, for example, suggest that judges now have some incentives that are different than they were before. Obviously, the way that the courts are being conducted change, whether there's fewer jury trials, due to difficulty of obtaining jurors or difficulty in having sufficient room to conduct those jury trials. So there's definitely what I'll call winners and losers. And you have to determine in your particular case or your particular situation whether or not you are a winner or a loser and how you could take advantage of that. And what I mean is, if you, for example, let's just say your company has been sued for $100 million, well, regardless of what you think about the merits of the claim, it can be a benefit potentially to that case being on a slower track. It could be a benefit to the fact that the plaintiff is going to have trouble getting that trial date or bringing that case to trial. It may be in your interest to kind of slow play that case. I wouldn't say that you're necessarily delaying. Obviously that would be unethical, but certainly you could take a more deliberative approach to that case. You could pursue more avenues of discovery than you might otherwise or be able to do otherwise, because you just know at the end of the day that the judge is not going to be pushing that case forward as quickly as possible. On the other hand, you may be in a situation where a case has already been in the system for a long time and a judge is really pushing a settlement. We'll talk a little bit more about that later, but my point is it may not be entirely clear whether you are a winner or a loser, but that certainly can change your calculus. I think it changes your calculus in terms of filing a case, because if you know, for example, that the average amount of time that a case is taking in a jurisdiction is longer than it was pre-pandemic, that can impact costs and it can impact when you might get some recovery from that case. I think it can impact your decision whether to file. In addition to that, when you're in the thick of a case, I think it can definitely impact your decision to file certain motions, to seek certain discovery, and your own sort of forecast or prospect for how that case can ultimately be resolved. I really think now the choice of venue matters more than ever. I think we're all used to, when we have potentially a choice to file in federal versus state court, or to file in one jurisdiction versus another, we have a tendency to focus a lot on the law in those specific areas, which of course is always an important consideration and very well may continue to be the paramount consideration. But on the other hand, it also, I think that the sort of issues that we're raising here need to be part of that conversation. In other words, if there's a particular jurisdiction you can file in that, as Justice Slang mentioned, doesn't have masking requirements, where they are trying cases on a daily basis and working very hard through their backlog, that may be very appealing to you as a plaintiff, or in a particular type of case where you're trying to get a quick resolution. There are other jurisdictions that have struggled with the pandemic that are still buried in a backlog of cases, or that have had difficulty managing and moving to a non-face-to-face environment. Those jurisdictions, I think, can offer challenges if you're a plaintiff. I think you also have to think carefully about what you file. In other words, do you really want to seek a jury trial? That may very well be the right thing. I'm personally biased towards jury trials as a jury lawyer, but as a jury trial lawyer, I enjoy jury trials more, and I have faith in that process. But nonetheless, that does put you on a track that could be slower. Certain claims that you have might slow down the resolution of the case, might be more difficult to present if you are in a jurisdiction that, for example, is not allowing in-person argument, doesn't have much in-person argument, and you have, let's say, a patent case. I've been in court appearances for very complex issues in a highly technical patent case where we had to do all that over phone with no visuals other than what we sent the judge in advance. So I think thinking about what you file and taking into account the changes from COVID, I think, are very important. And I think that for plaintiffs, alternatives to litigation can really be more attractive. I mean, I think I often caution clients who are considering bringing an arbitration that the reduced discovery that you get in an arbitration, the fact that in an arbitration, for example, you don't have an appellate process, all of that can weigh against an arbitration in certain circumstances. But now, ADR is more attractive to a plaintiff than it has been in the past, just because obviously folks who are getting paid by the hour and have been operating throughout the pandemic are in a different position, have a more streamlined process, are in a different position than the court system. And last, you want to work with your judge, not against her. I think it's very mindful. You have to be very mindful when you're in front of a judge nowadays that the judge's docket is still backlogged, that they are trying hard to clear their docket. I always am trying to earn brownie points with the judge and making sure the judge understands that I'm not wasting her time, that I'm helping her get through the docket, that I am not a person who is trying to delay or filing motions that are unwarranted. I think you have to be more careful than ever about using your discretion when it's filing a motion or raising a matter to the judge, given the backlog that we have. And then I will just say that if you do want to resolve a case or settle a case, that your judge often can help that, and that could be good or bad for you. In other words, if you don't want to settle a case, you could have a situation where you're getting a lot of pressure from a judge to do so, and that sometimes can be heavy-handed or unwarranted. But in other circumstances, that can actually be helpful to you if you're trying to bring the other side to a resolution and they're not realistic about the situation they're in. I have seen quite a bit of judges trying to push cases towards a resolution, and I do think that is something you should be cognizant of, and it should be part of your strategy. All right, we've reached our first secret word, and our first secret word is sunny. Please select the current word from the list below. Once again, the secret word is sunny. So please select that from the list below. I'm going to give everybody a minute. So if you've been doing something else or you're multitasking, you have time to get here and make sure you click that secret word, which is sunny. Please do that before we move on. Once again, if you got distracted, the secret word here is sunny. You still have a little bit of time to click that before I move on. Please click sunny before we move on from this slide, which I will be doing in a little bit, and getting into some hot topics, some very specific topics. But sunny is the word you need to click. Okay, I'm moving on. Hopefully you click sunny. Now we are moving on to the next slide, which are hot topics in litigation: causation, government enforcement, mandamus, and healthcare. I'm going to turn this over to Justice Lang now to talk about causation.
Thank you, Renato. Causation, obviously, that's a critical piece in any litigation. Expert testimony, Daubert, the challenges to expert testimony and causation, and injury-specific causation evidence is all before the Texas Supreme Court in the case of Helena Chemical versus Robert Cox. It has been fully briefed. I filed on behalf of clients 2 amicus briefs on that. Here's a little bit of facts there that I can tell you about, and you'll see why this causation issue is such a significant thing. The facts are that in West Texas, which is vast plains, ranches that are 1,000 acres or even bigger, are everywhere. And dotted around these cattle ranches are typically cotton fields. Cotton grows well in sandy soil. It can thrive in fairly dry, arid climates. So that's what you would see if you're driving out in West Texas in a few hundred miles west of Fort Worth. Helena manufactures, among other things, an herbicide, a weed killer, and it just so happened that a huge cattle ranch called the Spade Ranch out in West Texas, the owners wanted to get rid of mesquite trees, which are, they're very prolific. They grow up, they suck everything out of the nutrients out of the ground, and in order to provide more feed for the cattle, and it takes quite a few acres per cow out there, they try to get rid of mesquite trees. So the best way to do it on a big ranch, of course, is to take a crop duster plane and spread that herbicide liberally over the whole ranch. Adjacent to this particular ranch, for many, many miles, were these cotton fields. And it appeared that, according to the record, that the wind was a little bit high on the day that the spraying was going on the Spade Ranch, and there was some overspray, they call it, when the spray is actually pushed off because of the wind. The question was, where did the damage come from in the cotton fields? And there have been other spraying out in that area, so there's a question of causation. Well, there were 111 cotton fields that were affected, apparently, by some herbicide or other. And of course, Helena and the crop dusters were saying that's not necessarily our herbicide that caused the damage. Well, these 111 cotton fields were spread in an area that was 1.8 miles to 25 miles from the Spade Ranch where this spraying went on. So what the plaintiff's lawyers had to do was go out and figure out, by taking some samples, what residue showed up in the samples of damaged cotton, and was it the chemicals that were in the Helena product or not. Well, the problem with all this was that the plaintiffs only took samples from 6 out of the 111 fields. And they took about 2 samples per field. And they were dispersed over the whole 111 field area that they just at random apparently picked various fields to check. And the plaintiff put together what Helena is calling a patchwork of about 15 experts who fit in one way or another, kind of like puzzle parts, to end up opining that it must have been Helena's product that was blown over to the cotton fields that caused this significant damage. Well, as you can imagine, in the trial court, Helena's position was that, first of all, the experts' opinions were speculative. They were not based upon actual fact. It was junk science. There was no way to actually show how this cause occurred or how this damage occurred just by taking samples out of 6 of 111 fields spread over this vast area, when there had actually been some other spraying in that area during this time of the year, which was apparently the prime time to do it. The trial court agreed. It struck the experts on the grounds that it was not reasonable contemplation, that what they were coming up with was more than speculation, and granted a summary judgment in Helena's favor. As you can imagine, the Cox plaintiffs appealed to the Court of Appeals. Now, we have 14 different district court of appeals in this state. It's a vast place, and the appellate court that it went to is in a small, formerly very active hamlet by the name of Eastland. And the Eastland Court of Appeals took this up, very competent bench, I know them, and but they decided to reverse the trial court. They wrote a lengthy, at first blush, well-reasoned opinion, and said, this is enough to get to the jury. And the problem with that decision was, according to Helena, was that the court was looking too narrowly, or was not looking narrowly enough at what was really being presented. This patchwork, this puzzle was what they were presenting, and it was pure speculation at the end as to whether there was really anything there. And one of the examples that they pointed out was that the Court of Appeals, when they were confronted with this question, look, it's only 6 out of 111 fields that they actually tested. And the court started off with a fairly cavalier statement and said, well, first of all, each field does not comprise a separate plaintiff. Apparently, there were only, like 10 plaintiffs. But Helena's position was, what does that have to do with causation? And so when there's an appeal from most cases from a court of appeals in this state to the Texas Supreme Court, you have to file a petition for review, and the court has to decide whether they're going to take it. There are several ways that the court could reason on an idea that they would take it, or they could just decline to take it, and that would leave the Court of Appeals opinion intact with this position that Helena says is just pure speculation, and it lays wide open Dauber claims and causation in Texas, so that all you have to do is maybe throw something out there and you can get to the jury. The Supreme Court reviewed the petition for review, which is normally a shorter briefing, a more summary brief than you would have on the merits, and the response from the Cox plaintiffs and our amicus brief, and said, okay, we're not necessarily going to grant the petition, but we want you to do briefing on the merits, which is full-blown briefing according to the rules. And so that was done. We filed another amicus brief, and now it's at issue and will probably be set for oral argument in the fall. So the issue is clearly joined on this. The industry, the herbicide industry, which is a lot of big companies, and are looking at this very carefully, because if the Texas Supreme Court does not correct what Helena says is the error, it's really going to open up causation here and make it much easier to put together what Helena was calling junk science and no causation. So you can go to the Texas Supreme Court website, look up this number 20-0881. It's easy to pull up the case, and you can get all the briefs there. And it's, I will say that both sides did a pretty good job on briefing it and showing the issues. So the whole point of this is that the Supreme Court was going to have to look at it If they decide to go with the Court of Appeals, some say that it will be a total turnabout and will put causation on its ear in this state. As you can imagine, a lot of people do plaintiff's work will be very pleased to see that, and most of the chemical companies will be quite upset. I predict that they will try to, whatever happens at the Supreme Court of Texas, they will try to take it to the Supreme Court of the United States.
All right, so now, all right, Justice Lang. So next slide is government enforcement. I want to talk about this because I think we've seen some pretty significant changes. So first of all, just to hook on the initial theme in the beginning, because I do think the pandemic has been such a major change, I do want to make note of the fact that investigative activity was not curtailed by the pandemic, even under the prior administration. In other words, there were significant impact on cases that were actually filed or brought. In other words, if there's already an existing criminal case or a regulatory case, if the SEC has got a civil case, for example, those cases obviously were subject to the same forces that we discussed early on in this presentation. But what I actually saw was an uptick in investigative activity, even in the later years of the prior presidential administration, because I think government lawyers had more time on their hands because they were in court less. Whether they were on Zoom or teleconference, or if there were just less in-person hearings, less trials, what I noticed was that government attorneys of all stripes in all sorts of agencies, whether it was NHTSA, the FTC, the CFTC, any agency that I've encountered, what I noticed was that they were turning to old cases, that they were running out ground balls that they wouldn't have done otherwise, often where I could count on the government to not follow up on something. I was, in fact, getting follow-on requests, things like that. So don't be under the mistaken impression that the government is overwhelmed by the pandemic. That has not been what I've seen. I think it certainly impacted their decision of whether to bring cases, into actual courtrooms, but it definitely has not impacted their investigative activity. If anything, it's gone up. I also think that the change in administration has really produced changes across the board, and I've seen it in a number of agencies that I'm interacting with. For example, I have a very significant FTC matter that I have right now, and I've seen an approach from the FTC that is incongruent with what I had seen in prior years, which is not surprising. The new head of the FTC is someone who's written about, for example, concerns about monopolization in the tech industry, views on monopolization that I think are more newer and more aggressive than courts have had in the past. And so as a result, the FTC has concerns about the maintenance of monopoly power or the extension of monopoly power, their view of market power, let's just say, into other markets that the FTC traditionally has taken a more conservative approach on, and certainly is more aggressive than a lot of courts, I think, would come out. And so, that has there's definitely been a significant change there from them. There's been a change also, what I've seen from the SEC and DOJ. What I'm seeing is, although certainly the DOJ was very aggressive on COVID-related cases and what they viewed as fraud in relation to healthcare matters, during the prior administration, I've noticed increased aggression in the white-collar space in the new administration, and particularly amongst the SEC, and which should be not surprising to all of you. Obviously, Gary Gensler, the new head of the SEC, has cultivated an image and an approach that he wants to get tough. And what I've noticed is that the staff has followed suit, and they're marching by the beat of that drummer. And I have noticed actual changes in how they operate. So don't what it suggests to me is that, to me, the cheapest, most cost-effective way of dealing with enforcement issues is to have very strong compliance, a culture of compliance, to have attorneys, that you're consulting with on a regular basis to avoid issues. And certainly that's something that I do a lot on the security side and for folks in the financial services space in particular, but I've done so in healthcare and other areas as well. One thing I will say is that pandemic-related cases are not going away. So what does that mean? Well, I had an uptick in cases that I was handling related to, as I mentioned earlier, fraud in the healthcare space, medical devices, and so forth. And that is not changing. In fact, the Justice Department has, announced the task force, and they've got a new person heading that up, and they are pushing forward those cases. They've got a 5-year statute of limitations, and they're going to use their 5 years. So I think we're in the years to come, we're going to continue to see these cases and are handling investigations in that area. In addition, PPP loans, there's a lot of investigation of fraud in relation to PPP. And I'm still seeing activity in that area, a lot of which has not yet been charged. And then crypto, I will just say I've actually spoken to regulators in multiple agencies regarding crypto regulation. I know the SEC and CFTC, as I've spoken to both agencies, want to have an important role. The CFTC is trying to claw to get a piece of that. They're very encouraged with the fact that the SEC Mr. Gensler suggested that the CFTC would be part of crypto regulation. You're seeing activity on the Hill where, for example, Mr. Gensler has gone to the Senate and talked about the need for regulation and for additional legislation. But you're seeing this across the board. I mean, I'm even seeing in the Justice Department an interest in crypto. So that is, I think, the first word off the lips of government regulators, and you need to, if you're in that space or you have some stake in that space, you have to be concerned and watching the shifting landscape from the government. All right, now we get to today's second secret word, which is car. So please select the correct word from the list below. That is car. I'm going to give you a minute to do that. So this is your opportunity to make sure that you're getting the full CLE, and we're going to end this right on time. I know we only have about a little over 12 minutes remaining, and we've got 2 more topics that we'll quickly get through. But in order to get credit for the full CLE, you need to select car now. I'm staying on the screen basically for 1 minute to give you that opportunity. Once again, secret word is car. So please select car on the list below. On the screen now, select car before I move on to the next slide. If you've been doing something else, make sure you pop in and select car. All right. Now, whoops, sorry about that. We now have mandamus. So I'm going to pass it back to Justice Lang.
Thank you.
The remaining 12 minutes here. Mm-hmm.
Okay. Mandamus. Before I went on the bench, I think I filed 1 petition for writ of mandamus. Now I see them all the time. Mandamus is one of the few ways that a litigant can get an appellate court to make a decision on a ruling by a trial court before the case is fully over with. So I call it an opportunity for mid-course trial court error correction. That is, if a judge makes a ruling on discovery, for instance, where the judge you believe is made an erroneous ruling in compelling you to produce attorney-client privilege documents, for example, and you're wringing your hands saying, gee, do we have to wait until this case is tried on the merits? And they can use all of this discussion we had that was privileged information and go to trial with it, where we questioned our position in various situations? And the answer is no, you don't necessarily have to. You can go to the appellate court filing a petition for writ of mandamus to ask that court to correct what you are claiming was an erroneous decision by the trial court. So you don't necessarily have to take a body blow and just deal with that and go forward. Now, there are two particular things that you must prove. And let me tell you a little bit more about why this is an important thing to go forward with. When I was on the Court of Appeals, about every other month, I had duty with a couple of the other justices on our court to review the petitions for writ of mandamus that came in. We had to decide very quickly whether there was an error that the trial court committed and whether there was any adequate remedy by appeal. In other words, should they just wait until the end of the case? We had anywhere between 15 and 50 of those that came from all the trial courts in our district, which was a very populous district with lots of trial courts. So we granted very few of them, but the ones that we did grant, there was clearly a reason to do that. First of all, you have to present and convince the Court of Appeals that the trial court abused its discretion. Now, abuse of discretion is that doesn't necessarily mean that because you disagreed with the trial judge that she was dead wrong. She could have been in a position where she made a judgment call, and it could not be called an abuse of discretion. One of the best definitions I've heard as to what abuse of discretion means, that it's a decision outside the zone of reasonable disagreement. In other words, there are some bumpers on this decision, and this judge made a decision, and it wasn't so outlandish that it was outside the zone of reasonable disagreement. The second thing is to demonstrate that there is no adequate remedy by appeal. In other words, is it going to be an error that will infect the whole case? And you can't change it. You can't, you say to the Court of Appeals or the Supreme Court, you just can't put the genie back in the bottle on this deal. And so if you can convince that Court of Appeals or the Supreme Court that that is the case, you might get some remedies. Now, let me tell you, this is also an available remedy in federal courts, but federal courts are less likely to render a writ of mandamus and instruct the trial court, change your decision right now. I've read many of the federal court decisions on mandamus. They, too, do not grant too many mandamus petitions, but the fact of the matter is that they are much less likely to instruct their brothers and sisters on the trial bench that they made an error than we were on the Court of Appeals. And we didn't do it cavalierly. There are two quick examples that I want to give to you of cases in Texas to show you there are some very unique situations where mandamus is going to apply. It's not just discovery. It goes way beyond that. The Texas Supreme Court decided the In Re Centerpoint Utilities case in late 2021. And that's a very interesting case where there was a question about whether the trial court had jurisdiction over the question of whether the utilities electrical system was defective. The plaintiff was actually the estate of a person who was accidentally electrocuted. Well, the key issue, like in any case, is there something defective here that caused the demise of this poor individual who was electrocuted or not? In Texas, like in any other state, there are many subdivisions or departments of the state that deal with various issues, like, for instance, utilities, the insurance commission, you name it. There's a host of them. They all have their little domain and jurisdiction. It just so happens that the Public Utility Commission in Texas purportedly has jurisdiction over things that include, according to statute, utilities, rates, operations, and services. Well, the utility that got sued in this case said, wait a minute, whether this connector that you said was defective was in fact defective is to be determined by the Public Utilities Commission, by the experts. And if they decide it was defective, then we come back to the trial court and actually try the damages. If they say it's not defective, the case goes away. Well, the Supreme Court got this after the Court of Appeals decided that there was no jurisdiction at the PUC. And the Supreme Court, in a split decision, said, look, this is not the type of thing that deals with rates, operations, or services. This has to do with a product defect that was the result of the way that the utility actually constructed and put this particular connector together.
Justice Lang, I'm sorry, we've only got a little over 3 minutes left. So let me unfortunately, I've got to jump in and wrap us up to keep us on time for everybody who's listening. So I apologize for that. But I am for everyone listening. Frankly, you can reach out to Justice Lang. He's got, so you can tell, just sort of a wealth of experience in this area. I'll just briefly, because I know we're short on time. I want to make sure everyone is out on time. I'll just say on the healthcare slide, you can read it yourself, but the bottom line is that what I'm seeing, I'm not only seeing the COVID-19 related fraud that we've discussed, both on the civil and criminal side, a lot of civil, by the way, litigation over that, counterfeit products and other litigation. But also False Claims Act litigation is booming. I'm handling a bunch of FCA cases, and the government is pursuing a lot of FCA actions. Just to you see the statistics there, $3.2 billion in one quarter after $2.2 billion in all of 2020. It's a very significant increase there. And then I'm seeing increased state court litigation involving state laws that are broader than HIPAA. Given the healthcare focus we've had in the last few years, that should not be a surprise to any of you. But before we go, I want to not only give you an opportunity to ask any questions, but more importantly, just plug the rest of our business litigation webinar series. You should have a list of other opportunities. There's one coming just this afternoon. Absolutely fantastic group of powerhouse women who are doing a webinar later today on business divorce. You can find all the information regarding these other webinars on the TC website. So I would really encourage all of you to ensure that you take advantage of those opportunities. We've got another a couple of webinars coming next week as well. And the other thing that I really want to make sure that I cover with all of you, and I'm trying to keep this exactly on time because I know all of you are very busy, and I'm watching the clock because we have to hit just enough time to award the CLE, is that there is going to be a survey that's going to display at the conclusion of the webinar. And what I would just ask all of you is to please take that survey. If you submit the survey, that will give us the feedback you need. And I would just encourage all of you to, certainly submit questions to us. Justice Lang, as you can tell, just a wealth of information, wealth of experience. He would be happy to answer your questions, and so would I. And here is information on the other webinars. So like I said, the Powerhouse Group later today talking about how to end a business relationship without litigating. We also have defending class actions on June 1st, 11:30 a.m. Central, and then ethics credit, which is fantastic, at 1 p.m. Central on June 1st as well. Thank you so much for joining us. We did hit the 1 hour mark and we got our full CLE. Please take that survey. Thanks again for joining us.